Apologies, class. We had network failure. So I was explaining the rules to be taken into consideration when we are talking about the term consideration. So the following are rules governing consideration. The first one is consideration must move from the permissive. Consideration must be sufficient, but must not necessarily be adequate. Consideration must not be illegal, immoral, or contrary to public policy. Consideration must not be vague. Consideration may either be executory, that is, to be done in the future, or executed, but must not be passed. I've mentioned all of this before the network went unstable. So what is important in every contract, as an accounting student, you need to understand the focus of consideration. Our focus is benefit in contract. Our focus is profits in contract. Our focus is gain in contract. And if the contract is not properly managed, if the dealings is not properly managed, then it might bring about a loss. And this is popularly explained in Curry and Mesa, where it is stated that a valuable consideration in the sense of the law may consist either in some rights, interest, profit, or benefit accruing to the one party, or some forbearance, detriment, loss, or responsibility given, suffered or undertaken by another. The fourth element of contract is capacity to contract. Capacity to contract. Here we are talking about ability to enter into a contract, to acquire the right and incur any obligation under that contract. For a contract to be binding on you, under common law, you must be of the age of 21 and above. If you are below 21 years, the law refers to you as a minor. Yeah, you are an infant, so you don't have capacity to contract. So in general, anybody above the age of 21 who at the time is sober and mentally unimpaired is capable of contracting. So what we are saying in essence is this: you are 21 years and above, you are mentally okay, you are not derailed at any point in time, you can enter into a valid contract. However, certain categories of persons have no capacity to contract, or they have limited contractual capacity. A minor or an infant. A minor or an infant is anyone below the age of 21 years old in common law, and for the purpose of contract, below 21 years old, you are an infant. But under the Nigerian law, if you are below 18 years of age, you are an infant. A drunken person has limited capacity to contract, and in certain cases doesn't have capacity to contract. And in same person, someone that is a lunatic, a madman or a madwoman, a mad person, put to say, do not have capacity to contract. Now let's appreciate domestic agreements. I mentioned in my earlier discussion where we looked at husband and wife. A promise between husband and wife, is it a valid contract? Is it a valid promise? If we have a situation where there's an agreement, either the wife or the husband did not fulfill the part of the agreement, would they be liable? Let's appreciate that. Domestic agreement or domestic arrangement are made between husband and wife, parent and child, and among relatives. Arrangements between these people do not result in contract at all, because the parties do not intend and would not have legal consequences. So just like I mentioned at the beginning of my lecture, that a domestic agreement is devoid of legal enforceability, no intention to create a legal backing, they did not have intention to have a legal consequence, as the case may be. Now, let's appreciate this question. Adebimpe is a businessman and the sole proprietor of Adebimpe and Associates. In January 2015, when he went to travel to Benin, when he wanted to travel to Italy, Akpeke, his wife, could not go with him as usual because of a highly paid job. As compensation, Adebimpe promised to buy for her 3 different types of jewelry and send to her. Unfortunately, he forgot to do so. Akpeke is considering suing Adebimpe, advise her. This is a pure domestic agreement. This is a pure domestic arrangement. An agreement between husband and wife lacks legal enforceability. Thereby, it's something that can be settled at home out of court. Now, going to the question, the fact in issue here is Adebimpe promises his wife, but did not fulfill his promise. Can the wife sue Adebimpe? Will she have any chance of winning the case? The answer is no. On what grounds? This arrangement is a domestic arrangement. It is an arrangement between husband and wife with no intention to have legal consequences. As a result, the court will not entertain it. Your advice to Akpeke is she should not consider suing Adebimpe because she stands no chance of winning the case. However, it can be settled amicably between them. So that's the issue here. Because there's no intention to have legal backing, or they do not have any intention to have anything of legal consequences, then the court will not entertain it. And that is what we mean by its lack legal enforceability. You cannot enforce it in the court of law. Now, what are the terms of contract? We have the implied terms, we have the express term, we have the conditions, and we have warranty. In a simple word, let me start with express term. Express term of contract are terms that are stated and agreed upon. They are written. It is signed off by both parties involved. For implied term, it's opposite of express term. Most of the implied term are oral words. They are oral expressions, and they are read into the contract by the conduct of the parties involved. Condition goes to the root of the contract. It goes to the root of the contract, while warranty does not go to the root of the contract. Condition is the major part in a contract. Warranty is subsidiary to condition. So, but what is important is, for terms of contract, we are looking at what validates a contract, even though we have some element of that contract. So, contract can either be established with the word of mouth. Contract can be established by the conduct of the parties based on the custom of trade in the case of implied terms of contract. Contract can be established where the terms and conditions are expressly stated and agreed upon by both parties. Conditions are those major parts of that contract. They are the integral agreement in that contract, and it goes to the root. A breach of condition can bring about an end to that contract, and also the aggrieved party to sue for damages. But for warranty, it's subsidiary to condition. It's not an integral part of the contract. It does not go to the contract. A breach of warranty cannot bring about the end of the contract. However, an aggrieved party might sue for damages. Doctrine of privity of contract. This is another interesting subtopic. Privity of contract. The objective around privity of contract is, if you are not a party to a contract, you cannot suffer any loss in that contract, nor can you enjoy any benefit in that contract. Yeah. A stranger to a contract cannot enforce a contract. For instance, there's a contract between party A and B. Even though the contract is established for the benefit of party C, in as much as the party C is not part of the contract at initial establishment of that contract, it cannot enforce that contract. And that is the objective of purity of contract. A stranger to a contract cannot enjoy the benefit nor suffer the loss of liability in a contract. That is to say, if you are not a party to a contract, you cannot enjoy the gain or loss arising from that contract. Even though the contract was entered in your favor, in as much that you are not a party to that contract, you cannot sue for damages in the case of breach of contract. For some elements, we call them vitiating factors. Why do we call them vitiating factors? They render a valid contract to be invalid. The existence of this vitiating element will bring about a valid contract to be no longer valid. And what are they? They are just three: mistakes. In a contract, mistake occur when you believe a fact exists when it does not exist. We have situations where you believe that your family owns a landed property in your state, and unknowingly to you, that land has been sold. But you still believe you have landed property in your state, so you are looking for buyer. You get to that land, and it was later discovered that the land has been sold. That's a mistake. Misrepresentation. Misrepresentation can come in three ways. The first one is innocent misrepresentation. The second one is fraudulent misrepresentation. And the third one was negligence misrepresentation. When we say misrepresentation in law, misrepresentation represents a statement used to arouse someone to enter into a contract. Yeah. Most of the time, it is a false statement that is made to arouse your interest to enter into a contract. And we see that in the recent time where people market their product, make the product look like the best of the best, make whatever they are doing to look like the best of the best, and people are forced. People are aroused. People are moved. Then they come into that business, and at the end of the day, they lose everything. Ponzi scheme is a very good example of this. Duress and undue influence. If you have a situation where you enter into an agreement or into a contract based on influence, based on the fact that the person is more superior to you, you cannot tell the person you are not doing, and you sign up on that contract, it is a vitiating element. It will not make the contract to be valid. It can even make the contract voidable at the end of the day. We have instances whereby, in coming up with a contract agreement, there are certain elements that exclude one party or totally, or let me say that limit one party or totally exclude the party from liability arising from events in that contract. So such is what we call exemption clause. The objective of exemption clause in a contract is to limit or totally exclude a party from liability in the event of an event. In some areas, in some banks, you will see an inscription on the signboard where it will be clearly stated, car parked at owner's risk. So if you park there and your car is stolen, I'm not sure you can sue the bank. And if you try to sue the bank, you cannot win that case because it is clearly stated, car parked at owner's risk. So the The major point they are passing across to you is that they will not help you to look after your car because it's at your own risk. If you park here, it is none of their concern. It is not within their purview to look at. So this kind of thing, we call them exception clause. So the objective is, before you can say an exception clause is valid, we also need to appreciate about two elements. At the point of entering into the contract, exception clause must be bring to the awareness of the parties involved. Yeah, the two parties must be aware of that exception clause. Not after the event has happened, now say, no, we issued a disclaimer on this and we are not going to take responsibility of this. It must be stated and the two parties must what agreed on it. And when we are talking about liability, an exception clause to be operative, the contract itself must be a major part. Because if there's an exception clause is not communicated to the parties involved, or if the two parties did not agree before signing up on that kind of exception clause, then you cannot sue for damages or what have you. So what we are saying in essence is that for an exception clause to be operative, it is important that it must be brought to the awareness of the parties involved. It must be clearly scripted and signed upon. So now we have instances where you enter the bank and at the car park, you see car park at owners is. In this case, yeah, it was brought to your awareness by that inscription, but you didn't sign off on it, right? But the court conclude that in as much that it is clearly written, then you are at liberty to either park there or not. So whatever you do is at your own discretion. So if your car is stolen, you cannot sue the bank, you cannot sue the hotel or wherever that event took place. For every beginning, there's always an end. Now we've appreciated the element of contract, we have appreciated the limiting factors in a contract, we have appreciated the terms of contract. Now, what are the various ways under which contract can be brought to an end? We call that termination of contract or discharge of contract. We have about 5 ways under which contract can be brought to an end. Yeah, 5 ways. The first one, by death. I didn't put it here, especially where the contract is just between two parties. Number 2, by agreement. At the beginning, most of the time, you agree on when you want the contract to come to an end, at what point. By frustration. For contract to be discharged by frustration, we are saying that the event that brings about the end of, that brings about the contract come to an end is not caused by either of the parties. That is, none of them is responsible. For instance, if you have a business in Ukraine or in Poland, automatically your business has failed. Why? Because of the war existing in that place at the moment. Discharge by performance, yeah. Here we are saying that the objective of coming together have been achieved. The two parties have discharged their own part of the contract, then the contract can be brought to an end. By breach of contract, we mean, for instance, two people are in agreement to carry out a service, and one will buy, let's say product, for instance, selling of product. So one will go to the market to buy, the other will do the marketing for the sale. The person that is going to market is doing his own part by going to market to buy, while the other partner is not doing marketing for sale. That other partner, that act is what we call breach of contract. Yeah, so breach of contract. You are breaching the contract by not doing your own part of the contract. So an innocent party can actually repudiate the contract and in addition can sue for damages. Damages mean suing for monetary compensation of whatever he or she has suffered in that contract. What are the various circumstances to consider that, okay, there is frustration, that contract is discharged by frustration? So circumstances, what circumstances will a contract be terminated by subsequent impossibility of contract? So I mentioned earlier by frustration. By frustration means that the two parties, is not by their action that the contract was brought to an end, but by an event that is above them. A very good example is personal incapacity. Incapacity will generally render the contract frustrated. Yeah, maybe for health reasons, at some point you are not just strong enough to work, where the contract become illegal to perform. Yeah, as at a point, a contract can be legal. For one reason or the other, the regulation in that state can make it illegal, that it has been frustrated, right? Where contract cannot be performed in the specific manner. So we have regulation country by country and how you should operate in those countries. So where the law of that country do not permit you to operate it in the manner you want to, you have been incapacitated. In that case, the contract will be what? Frustrated. Yeah, we have a lot of questions to look at under contract law. The first one here, what do you understand by the term acceptance in relation to the law of contracts? And we explained to you that acceptance means approval to the terms of an offer. Yeah, giving consent to the terms of an offer. So who is expected to give acceptance is the offeree. Now, for an acceptance of a bilateral to be operative, certain conditions are fulfilled. And what are those conditions? We said for an acceptance to be operative, number one, it must not be conditional. It must be unequivocal. That's number two. Number two, we said there must not be counter offer. That is, there must not be variation to the terms of the proposal. Number four, we mentioned that it must be accepted within what? Reasonable time, without delay. And the last one, communication. It must be communicated to who? To the offerer. Ades offered to sell his car to Bala for 1 million. Chuku, Ade's friend, standing by, says, I will buy the car for 1 million if Bala does not. Bala is not interested in the car. Does contract arise between Ade and Chuku? The answer is no. There's no contract between Ade and Chuku. Why? Remember, I told you that offer must be direct. Offer must be straightforward. In this case, it's a direct offer. Who do Ade offers Bala and not Chuku? So no contract exists between Ade and Chuku because the contract was directly to Bala and not Chuku. A contract is not complete unless parties have capacity to contract. Explain capacities of parties and persons who lack capacity to contract. What do we mean by capacity to contract? Capacity to contract means an individual have rights to enter into a valid contract, incur liabilities, and also enjoy from any benefits in the contract. And who are those that lack capacity to contract? One, an infant. An infant, for the purpose of common law, is someone below the age of 21 years old. And that's what the contract law speaks also. But in the Nigerian law, an infant is anyone below the age of 80 years. So an infant is not capable to contract. The second person that is not capable to contract is a drunken person. Yeah. And the last person here is a lunatic, an insane person. These three categories of persons lack capacity to contract. So we have another interesting question. Chop and Chop Party of Nigeria, CCPA, invited Best Designer Limited, a firm of architects, to a meeting to discuss the possibility of developing their headquarters at Abuja. In preparation for the meeting, Best Designer Limited made the survey design and presented it at the meeting on February 20, 2015. The design was considered suitable for the job. At the end of the meeting, the quotation submitted by Best Designer Limited for the development of the headquarters was considered to be on the high side and was rejected. Best Designer Limited sent a bill of 200,000 naira for the survey design used at the meeting, but Chop and Chop Party of Nigeria refused to pay. Best Designer intend to go to court. With the end of decided case, you are required to advise the parties. Where examiner expressly state that with the aid of decided case, then you are expected to quote the case. But most of the time, we advise to them, where you are not sure of that case, please don't quote it. I'm going to give you this as assignment. So the Chop and Chop Party of Nigeria and the number 2, distinguish between with examples, offers, and invitation to trade. Let's give this an attempt and see if we can come to conclusion. But the objective of giving you number 2 is like a direct waypoint to number 1, because the question in number 1 is actually on invitation to trade. So with this, I believe you should be able to give me conclusion to number 1. So advise the best designer if they have or if they stand chances of winning the case. Thank you very much and see you in our next class. Bye for now.